Thanks everyone for coming. My name's Peter Bartlett. I'm the Associate Director of the Simons Institute for the Theory of Computing. Let me say a few words about the Simons Institute. It's the leading venue for collaborative research in theoretical computer science. It was established in 2012 with a generous grant from the Simons Foundation, and it brings together the world's leading researchers in theoretical computer science and related fields, as well as the next generation of outstanding young scholars to explore deep unsolved problems about the nature and limits of computation. And as well as promoting fundamental research on the foundations of computer science, it aims to expand the horizons of the field by exploring other disciplines through a computational lens, motivated by the fact that phenomena in many fields, including physics, biology, economics, or the models that those fields have developed for those phenomena, are intrinsically computational in nature. And the insights gained from these explorations often reflect back to the theory of computation, opening new directions. And tonight's Theoretically Speaking event certainly has this flavor. It's brought together a very distinguished group to discuss the intersection between algorithms and the law from multiple perspectives, law, ethics, philosophy, and computer science. We're very interested in exploring what are the challenges and opportunities presented by artificial intelligence and by algorithms more generally. It's become a more pressing issue as AI systems are being applied to a broader range of tasks and having a real impact on societies and individuals. And some of these are very familiar and some are new. So things like deciding who's creditworthy, deciding what news and messages will be passed on to us, deciding the actions that a self-driving car will take, deciding on guilt and parole, deciding on who gets a job interview. What are the social and humanitarian risks, and how does society address them, particularly through legal mechanisms? And in the other direction, what opportunities might this technology provide in the arena of law and governance? And we're delighted to have a very distinguished group of panelists to discuss these topics. Martha Minow from Harvard University, Patricia Williams from Columbia University, Shafi Goldwasser from the Simons Institute, and Elliot Schrage from Facebook. Let me start with a brief introduction to each, and then I'd like to say a little bit about the format that we'll use tonight. So Martha Minow is the 300th anniversary university professor at Harvard University.
I'm 300 years old.
You
were preserved remarkably well.
She was a few years ago when she stepped down as Dean of the Harvard Law School. She's been teaching at Harvard Law School since 1981 and is an expert in human rights and advocacy for members of racial and religious minorities and for women, children, and people with disabilities. She's Vice Chair of the Board of the Legal Services Corporation, a bipartisan government-sponsored organization that provides civil legal assistance to low-income Americans. And she writes and teaches about privatization, military justice, and ethnic and religious conflict. And she's been elected to the American Academy of Arts and Sciences. So a big welcome to Martha. Patricia Williams is the James L. Doerr Professor of Law at Columbia Law School.
And I should say soon to be Director of Law Technology and Ethics at Northeastern University.
I didn't know that.
No,
So congratulations.
It's just happened. So.
Just between us and
yeah, congratulations.
And she's also served on the faculties of the University of Wisconsin School of Law, City University of New York Law School, and Golden Gate University School of Law. She's been Deputy City Attorney for the Office of the Los Angeles City Attorney and has served as staff lawyer for the Western Center on Law and Poverty and has published widely in the areas of race, gender, and law and on other issues of legal theory and legal writing. Her books include The Alchemy of Race and Rights, which won the Bruce K. Gould Book Award, The Rooster's Egg, and Seeing a Colorblind Future, The Paradox of Race. Pat has also been a columnist for The Nation. She writes the column The Diary of a Mad Law Professor on issues of social justice. She's been a MacArthur Fellow, has received the Alumni Achievement Award from Wellesley and the Graduate Society Medal from Harvard, and has served on the Board of Trustees at Wellesley College, the board of the Andy Warhol Foundation, and has been elected to the American Philosophical Society. So welcome, Pat. Shafi Goldwasser is the director of the Simons Institute for the Theory of Computing here at UC Berkeley and professor of electrical engineering and computer science at UC Berkeley, RSA professor of electrical engineering and computer science at MIT, and professor of computer science and applied mathematics at the Weizmann Institute of Science in Israel. So she doesn't easily give up positions.
Okay.
She's won
I don't
the-
know. It's never. There's no existence proof.
It's never happened. That's right. She's won the ACM Turing Award, has twice been awarded the Gödel Prize, and has been elected to the American Academy of Arts and Sciences, the National Academy of Science, and the National Academy of Engineering. Welcome to Shafi. I'm going to invite each panelist to give us their perspective on a particular theme in this area of algorithms and the law. And after we've heard from each one, we're aiming to have a discussion among the panelists, and I guess my role is to help spark that discussion. I have to say I was a little apprehensive about that. My expertise is firmly on the technology side of this debate. But then we've had, we really have a diverse range of perspectives here. And after chatting with each of them, I realize it's going to be very lively and lots of fun. I've enjoyed all those conversations, and I'm confident it'll be a fascinating discussion. And it's unlikely that anything I say will mess with that. So I'm really looking forward to it. I should say I might need to call a halt to that discussion at some point because we do want a chance for the audience to ask questions also, so we'll reserve some time for that. But one caveat, everyone here is speaking as individuals, not on behalf of their employers, so they can't answer questions on their employer's behalf. All right, so Martha, we're going to start with you. So Shafi invited you to give a talk in this forum, and you suggested this panel format. And you have lots to tell us about where rights and technology collide, let's say, and about the opportunities there as well. But perhaps I guess maybe it'd be good to start with why we're doing this and how it came about.
Great. Well, thank you, Peter, and thank you, Shafi, for this invitation, and thank you, Pat, and thank you, Elliot, because I just think it's more fun if we walk into a bar together. So, and we'll learn something.
We only have water.
We only have water. So,
Wait, that's water? Oh, how is it?
I am, as Peter said, the vice chair of the entity that funds legal services for poor people. So in that context, it is absolutely obvious to me that we will never provide lawyers for all the poor people in this country who need them and who deserve them. And what that means in practice, for example, is that people who are tenants and have a problem with the law end up representing themselves. 99% of them represent themselves. And people who are landlords have lawyers. And the typical hearing in a housing court is about 3 or 4 minutes. And if you have a lawyer, your chances of doing better, of succeeding, are much, much, much better. So that context led the Legal Services Corporation to give out technology innovation grants to grantee organizations, 133 around the country, who have developed some fascinating efforts using artificial intelligence, using other kinds of computer algorithms to help, for example, a veteran navigate the Veterans Administration medical care, to help people actually get some legal advice. So I'm interested. I see great promise. At the same time, my state, like many others, has started to use algorithms in the criminal justice system to decide who should and should not get cash bail, who should and should not get parole. And this I am really, really worried about. And so when I had the great good fortune to spend a year at Radcliffe, where I also was able to be with my old friend Pat and meet a new friend, Shafi, and we were describing what do we want to do this year. I think you said, I want to think about algorithms. And
machine learning, yeah.
Machine learning. And a group of us said, oh, we all want to do that. So out of that, came, I think, a really fascinating conversation. Cynthia Dwork here is another key member of that group. And out of that came a class. So we actually taught a class together. And this was a feat of technology because it cut across 4 institutions across the country, students from computer science and from law. That's the bigger divide, frankly, than between Boston, New York, and Berkeley. And we found that we had a lot to talk about, a lot of questions, a lot of possibilities. So I would add to your list, Peter, of the kinds of issues to think about. Blockchain runs afoul of the right to be forgotten. which is now a paradigm that the European Union has described, has actually implemented. There are collisions of that nature emerging every day, and at the same time, there are technological innovations that bypass legal regulations. That do an end run around the prohibition, for example, of using race or gender in employment. I don't have to describe how Uber does an end run around many laws. But other kinds of technological issues, face recognition, and should it be used by law enforcement, and what do we do with the fact that, at least at the moment, it's not very good at recognizing the faces of African Americans and some others. Privacy issues. I think the risk score question is not just an issue in the criminal justice system, but also in the banking system. Because if the data sets that are relied upon are themselves reflective of larger problems in the society, structural racism, for example, decisions about who has creditworthiness based on past creditworthiness, who is likely to be rearrested based on where the police have been located, not only is the algorithm going to be fed, garbage in, garbage out, but now it's also another step removed from accountability in democracy. And it's less accessible to a democratic process, partly because it looks like it's more technological and more scientific. This European Union point is an increasing issue. That is, there's regulation coming in from different parts of the world. And so even if the predicate in the United States largely is, we're not going to regulate, it's free speech, or it's private enterprise, it doesn't matter. It is going to be regulated. It is being regulated, and it's not just the European Union. Australia, the UK, Singapore are all involved in this. And I'm looking at Elliot because he's been trying to navigate that. So if the United States is not at the table, somebody else is making the decisions, and that seems like a missed opportunity, and we should be at the table, is my own view. I also think that there are opportunities beyond the kind that I described about access to justice that we should be pursuing. So in our class, we had the chance to think about how some tools from cryptography, zero-knowledge proofs, other kinds of tools might be available to help better implement rights, like protecting the sources that journalists have. And so there's just so many rich conversations we should be having, both ways. What are the tools, what are the possibilities that the new AI and computer science revolution affords, and what are the concerns that lawyers and ethicists and people concerned about governance may have. Now, I'll just say one more thing. The course was enormous fun, and we will have different iterations of it, but here was, frankly, my biggest learning. We don't speak the same language. We have a long way to go to even have these conversations, and I'll just flag a few, just words that we use to mean different things. Fairness. Fairness, I learned, for many computer scientists means accuracy, which is, that seems relevant. But for lawyers, that's, maybe relevant, but it's one of many, many different dimensions, which might include participation, transparency, opportunities for review, and having conversations about, do you want this? And having the response being, why would you want this? Totally fascinating. Another different word, a word with different meanings, is proof. What is proof? Well, I am now feeling embarrassed that lawyers are pretty vague about what we mean about proof, and we resist the idea of actually putting a number on the probability. That's actually, produce a mistrial if a lawyer actually says, here's the actual way to consider what the instructions from the judge mean. And computer science, quite beautiful and elegant conceptions of proof and probability. So that was another one. And I think just one more is transparency. So with machine learning in particular, now that I have some beginning understanding about the multiple levels at which machine learning is translating raw data into more refined and abstracted levels. My question about but what's going on in the inside seems naive, but I'll tell you, that is my question, what's going on the inside. And transparency, you tell me, but I think computer scientists have a different idea about what that involves. So I think we have a lot of work to do. There's a lot of promise and a lot of peril if we don't do that work.
Thanks, Martha. So, Pat, your column, the Diary of a Mad Law Professor, has had many very thought-provoking articles with titles like "Americans are finding new ways to join the surveillance state," and "Why everyone should care about mass e-carceration." Also, you were a co-organizer of this workshop with Cynthia Dwork at the Simons Institute this week, entitled "Wrong at the Root: Racial Bias and the Tension Between Numbers and Words in Non-Internet Data." And in discussions that we've had, you've raised questions about how the concept of self is affected by the widening use of algorithms, by numerical representation of individuals that use implies, and issues like the difficulties of challenging the status that's imposed on us by an algorithm. That's a very broad range of topics. Would you like to?
Sure.
tell us about that?
I think my concern begins with that of a contracts professor. I teach contracts. And I don't like seeing things handled as though they were contract when they actually are issues of criminal law, because they're completely different standards. And so this begins with a concern about proprietary notions being the central value of economic exchange embodied in contract law. And if efficiency and economic value is the most important thing, then, and you put an algorithm into somebody's ankle bracelet, or you put an algorithm into a predictive mechanism for whether or not somebody's going to be released or not from jail, you are bypassing a system that says we look at each individual, each case in controversy. That's what our constitutional protection is. It's an individually based assessment of who this human being is in time. If they've done something in the past that's wrong, our criminal justice system figures out some remediation that brings healing into the present. Algorithms predict what you're going to do in the future, what you haven't done, in other words. But if it's also done by an algorithm that is owned by a private corporation whose ultimate obligation is not to the public, not to res publicae, but to the stakeholders of a corporation, which are the stockholders, then that's mixing functions. It's a conflict of interest built into the machine as far as I'm concerned. It also makes it very hard to excavate exactly what's being judged, what's being put into the black box that decides at least part of your fate. And at least some of the algorithms have been suspected of, or actually proved to take into account things like where you live, your zip code. And that's not about your behavior. That's judging you by a groupification that if a police officer were doing that, we'd call it profiling, stereotyping. It's impermissible in the law, but it's buried, it's invisible in a proprietary. We don't have the right to bring that out in court. So it's a kind of silent witness, which also violates the idea that you have in trials the right, or if you're going to have these very consequential things of freedom or not, you're going to be able to cross-examine the witnesses against you. And these sort of mechanical witnesses, that's an aspect that I think is simply not fully taken account of in these very consequential uses. A second concern I have is that it is very disembodying. It is, and by disembodying I mean dehumanizing. It abstracts us, and certainly one aspect is that it judges us by a cohort by which, if it's race, if it's gender, if it's, again, where you live, it judges you by pinpoints that don't necessarily have anything to do with you. And I'll give you a personal example. At Columbia, we use a system called Canvas, and when I was being trained to use this, it's a platform for the non-academics where you get to the students get to talk to one another during the course of a class. You can put things on it, and everybody discusses it, but it frequently runs while you're giving a lecture. And I accidentally discovered that actually somewhere in the IT office, they're ranking the entire faculty by how many hits or conversations are had among students during the course of a
Class time.
class time. Yeah, yeah. So it's literally ranking you according to the Kim Kardashian scale, as far as I'm concerned. And I'm somebody who always tells my students, close your computers, you know, turn off your cell phones. We are going to talk to one another. We're going to have a different kind of conversation. Well, it turns out that as a metric of my status as a professor, if in fact I'm being ranked by this abstraction, not of what comes out of my mouth, but how many times my students are talking during the course of it. It doesn't matter whether or not I'm wearing a bright pink, you know, diamond-encrusted bustier. You know, it doesn't matter what they are talking about. Those data points are abstracted from what the substance of what's actually being taught. And, you know, it incentivizes me to be splashy or to generate conversation in very different ways. And that shift from the substance or from the particularities of what is actually going on in a situation to the, you know, to sort of, like, in facial recognition, you see all these data points substituting for a face. And it's a new kind of persona. I mean, if one thinks of the persona as, in Greek theater, literally a mask behind which or through which, it's something through which one speaks. Again, in American jurisprudence, that persona through which one speaks is a protection of both the internal privacy, but it's also the right to invent oneself, the right to create oneself, the right to be judged by what it is that you do, that you present to the world. And this is a kind of abstraction, it seems to me, that emulates some of the worst features about how we tag people who are stateless, how we tag people who are disenfranchised or marginalized, how we tag people who are African American in the society as the number one example of people who, as W.B. Du Bois put it, suffer from double consciousness, because you're never permitted simply to think about what you're thinking about. You always have to be aware of who is looking at you and what they're thinking. Are they talking? Are they saying the right things? And that's a kind of disembodying quality that I think that this brings to the table. That we have to think about how we want to, if that's a perspective we want to become normative, because it internalizes the panopticon in ways that whose consequences I think could be quite serious. And you see this as an extraordinary stress in populations who are already enduring that kind of constant surveillance. If this is the new norm for everybody, I expect you will see those kinds of stresses magnified. Finally, of course, this is an assortative mechanism with a very long memory. And it's a mistaken assortative mechanism because we really haven't had the kinds of conversations I hope we are beginning to have about who's in what population and who's in the comparative populations, how those populations have been set up, who is called black, who is called white, who is called male or female, are the simple examples of what you can get wrong. I have friends who are married. He is normatively white, I suppose, and she is Chinese American, and they had twins. In the hospital, the nurse came in and saw the mother with one of the babies and put on the certificate in the hospital that the baby was Asian. A few minutes later, the second baby came in with the father, and a different nurse came in and wrote white. And so it's kind of funny, but it also means that if that endures as a categorization, it indicates very different life chances. And that's magnified if you saw one baby as white and one baby as black. I mean, and it's not just about the perception of people's prejudice as you walk through the world. It's built into black box medicine about who is measured as what, whether or not you're going to amp up certain outcomes because you believe that race is embodied in ways that justify some of what we've been talking this week. For example, asthma monitors are actually adjusted for African American lung capacity, because that is a metric that goes all the way, the spirometer, it's still adjusted, isn't it? Pardon me?
It's horrible.
Oh, it's hard. Oh, I'm sorry. I thought you were disagreeing. Yeah.
Yeah.
No, but it's adjusted because there was a built into this machine, and the spirometer is 200 years old. And so it was built into the assumption that slaves had different lung capacity. It has never been taken out of the machine. So there are still adjustments. My son has asthma, and it's adjusted for African American lung capacity, which is different from every other human being on the planet. And that is just wrong, but these are things which are now being built more efficiently and invisibly into into not just the old-fashioned hand pump of breathing into it, but into assumptions that have to do with liver function, kidney function, blood, osteoporosis rates, and so forth. And these are unquestioned. They're unquestioned, and they have the authority that displaces, again, the human interaction of what we thought of was going to be precision medicine, which is each body speaking, but instead is being normed according to ancient and incoherent biologized categories. We're bringing the history of this kind of segregation, and now we are rebiologizing it in very palpable ways. The final thing I want to say is that because these machines store data essentially forever, the right to be forgotten isn't simply about clearing your credit record. It pins you in a way that I think of as a kind of institutionalized traumatic reiteration. When in psychoanalytic theory, if you can never forget something, it's literally like it's repeated over and over and over again. It becomes confining, this inability to reinvent, this inability to become a new person, to emerge from your last worst moment. And so we're inscribing people with a new kind of status. We're creating new caste systems, which make it impossible for people to escape. And in Anglo-American jurisprudence and most of Western dignitarian jurisprudence, the concept of amnesty, which Martha has written about so eloquently, is about the ability to forget, that you are forgiving, and it isn't just forgiveness, it is also a forgetting. You put it behind you. With this kind of mechanical long-term memory, it becomes impossible to forget, and you become literally cast as a member of a caste forever.
That's bad. So Shafi's going to tell us a little bit about some potential applications of computer science, I guess broadly in the legal sphere. One of the things that Shafi's famous for is her work on zero-knowledge proofs. So being able to verify that you know a secret without revealing the secret. So think of a protocol that allows me to prove to you that I know a password to something without actually sharing the password with you or anyone else. And people have proposed applications of this technology in verifying honesty without sacrificing privacy, for instance, in verifying compliance with a nuclear disarmament treaty without revealing perhaps national secrets, or maybe more mundanely in verifying financial transactions without revealing details of those transactions, or perhaps with respecting the right to have things forgotten in a sequence of transactions of that sort. So Shafi, would you like to tell us a little more about?
Yes, thanks.
Your
Given
interest
that
in
I
that?
am a computer scientist in the bar, and I don't speak as eloquently as the other members, I will use slides, okay?
And we have slide envy.
Okay. So I guess I am a theoretical computer scientist, and in fact, the Simons Institute is, you guys can turn around if you want. The Simons Institute is an institute that is about theoretical computer science and what it can do for computing and other sciences in society. It's a relatively young field, and certainly young field compared to law. And I guess kind of broadly defined, if we just wanted to use sort of intuitive definition, is we study the fundamentals of what can and cannot be done with computers and computer programs. And but more to the point of this particular seminar or panel, I think that over the last sort of 40, 50 years, theorists in computer science have shown sort of the ability to take very vague concepts and formalize them. things like what is it we want from what do we mean when we say that we want private communication? Or what do we mean when we say that we want to be able to compute on data while maintaining the privacy of data? Or what does it mean to define simultaneity for things, two events to happen at the same time? So these seem to be very intuitive things, but they require definition. But why do they require definition is because once we use computers that supposedly guarantee privacy, or they guarantee simultaneity, or they enable you to compute on data without actually looking at the data, we need to be able to set a goal for this system. And we want to give a precise mathematical goal so that later we can possibly prove mathematically that this system satisfies these definitions. So it's not good enough to have a vague definition. We need to have a formal way to talk about these things. And what does this have to do with the panel and with law? So as I understand it, and actually you both confirmed it, I mean, we've confirmed it in private, but you've also said it in this panel, that law is sort of intentionally vague. So that judges can use their judgment and discretion in deciding in court cases sort of on a case-by-case basis, and use context and review in order to render justice. And that's wonderful. However, so we all know that that we've got a lot of data out there, and regardless whether we have data or not, we have automated systems that stand to make a lot of progress. And one of the things that Martha talked about was making the judicial system more efficient by having help to people who between renters and landlords. But health, right, disease control by trend prediction, predictions for financial markets, economic growth, driving so that we can get to where we want to go on time. Facial recognition, which has downsides, but it also has upsides in vision. If you look at your MRI and you want to detect diseases, and you want to detect it reliably and not just because of the mood that the doctor has that day. Apparently, I know that for breast cancer, they claim that the same doctor, if he sees it in the 2 weeks later, he might give a completely different judgment, and we would like to have some consistency and reliability. And as you pointed out, it's now being used also for things like policing, bail, credit rating, things which have major societal impacts, okay, major societal consequences. And it's very important that in order to take advantage of the efficiency that these systems afford, perhaps not for certain areas, but certainly for others, that we are able to write laws, okay, that govern the behavior of these systems. And in order to be able to write laws, it's not going to be enough to use this vague language. So since we're talking about sort of these systems that actually have kind of a well-defined input-output behavior, then we need to make our laws more precise. We need to give definition of what it is that you want such systems to adhere to. And I think that theoretical computer science essentially has had experience in having done exactly that. So how to take these kind of, again, vague notions and give it a precise definition. Now, who is to say what's the right definition? I think this is an issue that can come up, and that's why we need to talk to each other. So in a sense, I think that people like lawyers, or exactly lawyers, or policymakers, they need to tell us, to discuss with us what it is that the law it mandates, what it is that a system should provide. But then we would need our expertise in order to actually give formal definitions that satisfy this. So the reason that I'm optimistic that we can do that is that I'm a cryptographer actually within theoretical computer science, and cryptography is a field where we've done that several times over. So we have given some precise definition to kind of intuitive notions, and not only in that definition, we're not just out for definitions. We are out for building systems which are better. So we want to enable progress, be able to do things we couldn't do before, like privacy and simultaneity and contract signing and commerce and so forth. But we want to do that the right way. So once we have sort of defined sort of the notions, then we can come up with systems and prove that the notions are satisfied. So some of these examples that I just want to mention in a word, I don't want to teach you. I mean, I do, but I know this is not the platform, and also from the audience, I think a lot of you know this, but I just want to give a few words about some examples which are good both from the point of view that they actually do this thing that I promised, that they define an intuitive notion, but they're also applicable for the law. and they've been shown actually useful to enable things like, for example, Martha talked about accountability, that there's some feeling that by having these automated systems, we're going to have less accountability. But I actually think that we can use some tools that we've developed to get more accountability rather than less. So some of this idea that it's less accountability, I think, is a little bit because viewing this, what we do is a bit like voodoo. And in some areas, it still is voodoo. So these facial recognition systems, they work, but we don't know exactly how to explain why, or they recognize cats and dogs. That's really Peter's thing, right? Not the cats and dogs, but okay, right, he's a theorist, actually. But, I mean, there's a lot of talk about how AI manages to do things without explaining. But I think we are at a certain point in time. This is not the end of the story. Okay, so let me just say something about these examples, just to illustrate how there are some things we can do which are remarkable and that can be useful for the law, in my opinion. So there's this thing called secure multi-party computation. And what is that? So first of all, maybe what it enables, because we are kind of a general audience, I would say it will enable doing things like advanced medical research and medical treatment while being compliant with HIPAA regulations. So what is secure multi-party computation? Again, before defining it, which is kind of the opposite of what we do in theoretical computer science, but it's better for presentation, it's a way for a bunch of computers, each of which has different data, to collaborate and, let's say, run programs on their union of everybody's data without actually sharing the data. So somehow we can use the wisdom of all these different computers to derive conclusions in medicine or research without actually giving each other the data. And in fact, this is, I think intuitively you should kind of believe that this is extremely useful. And in fact, it's gotten to the point that even there's a congressional definition of, so I'm just giving you the congressional definition rather than the computer science definition. And they say the term secure multi-party computation means a computerized system that enables different participating entities in possession of private sets of data to link and aggregate their data sets for the exclusive purpose of performing a number of pre-approved computation without transferring or otherwise revealing private data to each other. And this, in fact, is useful for things like, you know, if you have different hospitals. I don't know, here there's Dana-Farber and MGH, because I was at MIT before and I know the names of the hospitals there. Here, what do you have? Stanford, UCSF, Alta Bates. Yeah. And so let's say that they want to collaborate. They have different patient sets. They might be genomic institutes. And clearly, if they could pull their data together, then they could reach better conclusions. They could do better research because nobody has enough data in order to draw as much conclusion as you want. But HIPAA would say that you're not allowed to give medical records out to another hospital or to a drug company. So can you actually derive these conclusions without giving out the data? And these theorems, which were proved by computer scientists, show how to do it. So, but before they show how to do it, they define what it means to do it. And what it means is that you would be able to conduct the research and get the outcome of the research without knowing anything else about other people's data than what's implied by the outcome of the research. So the definition is actually very abstract and seems to be very ideal, and yet you can satisfy it. What's another example that you could do with this, which has some kind of a legalistic flavor to it? So for example, in Boston, they were running some, people wanted to know what is the wage disparity between men and women among Boston companies, and they don't want to reveal, of course, what they're paying to who, but BU University convinced many companies in Boston to go through a multi-party secure computation where they would determine what is the average salary of a man, what's the average salary of a woman in Boston, and then these companies could just decide for themselves, are they above or below? So there was some sort of benchmark. But this was no shaming involved, just a way to determine what the average is. And this is obviously something that I don't see how we can do that without these methods, without the mathematics. This is progress. You know, this is progress that I think would have also impact on what is legal and what's illegal, you know, in terms of wages. Okay, what's the other thing? The zero-knowledge proofs. So my sons convinced me to put this picture on. This is what I used to look like. I think I still look like that, but they claim I don't. But in any case, so this is zero-knowledge proofs. This is from the 80s, actually, at Berkeley. And the idea is that these are mechanisms to demonstrate that facts are true without giving information why they're true. And that is very relevant, you know, for something like what Peter said, you know, to prove that you are the right person who has authority to access, let's say, records on a computer or to purchase something on Amazon. But it's also useful for things that are connected to the law. And in particular, there's sort of a recent paper that my students and I wrote, and that is about how to help to ensure accountability, quite the opposite of lack of accountability in the courts. So the story here is that people probably have heard about the Foreign Intelligence Surveillance Act, which allows essentially, NSA to, or yeah, I think it's the NSA, to wiretap foreign nationals. And then there's some sort of a body of secret laws that determines when it's allowed and when it's not allowed. But since the laws are secret and the surveillance acts are secret, it's all done without any kind of accountability. So wouldn't it be nice if you were able to sort of prove that you are consistent with some sort of body of secret laws without actually revealing what those laws were or what the surveillance requests were. And zero knowledge proofs seem to be totally suited to it. Now, this is all theory. I'm not saying that I know how to write the set of secret laws as a computer program and then to prove that that computer program was executed properly. But theory does have a tendency to be translated to practice when it offers something good. So I'm optimistic these things can be done. And this foreign surveillance, maybe it's the least of our problems because as Americans, there's actually a federal docket that allows, the FBI to request Facebook or Google or any of these other companies the access to your digital content and your emails and so forth. And of course, you have to go to a federal judge and request a court order. But it turns out that even though these surveillance orders are supposed to be sort of revealed to the public after a certain enough amount of time passes, and it's not anyway, and it's no longer insecure, because obviously while you're being surveilled, if the person who was being surveilled knew about it, it's not a good idea. Even I, with my limited criminal abilities, know that. But it's written into the law that this secrecy has to be lifted within 30 to 60 days, and it turns out that it actually doesn't happen. In fact, so this Judge Smith from Texas wrote a few papers about it, saying that these judgments are made in the shade, and that it's gagged, sealed. Basically, things are not revealed, and that means that there is no opportunity to scrutinize these laws. There's no opportunity to check whether it was given, rightfully, the surveillance order or not, why these surveillance orders were issued, and so forth, or even what the magnitude of the problem is. So in fact, the only way that we know how many of these things happen is because I think companies such as Facebook and so forth, they release these, in Google and Microsoft, they release these reports every year saying how many surveillance orders they were asked for. But we have no way to check that that's correct. They might be underplaying it, they might be overplaying it, they don't say why they were requested, so it's hard to say for which purpose the FBI asked for it. And the reason I'm talking about this is because, again, we could build a system that uses both zero-knowledge proofs and secure multi-party computation that if the judges are willing to adopt it, and we're working with Judge Smith to try to convince other judges to adopt it, could enforce federal judges to somehow secretly commit to the surveillance orders that they've granted, and then make sure that they actually lift the secrecy orders, and also be able to aggregate how many of these surveillance requests were issued. And there's a whole architecture to it, and that's already technology. So in any case, I think that's all I want to say. I guess my conclusions are that I think that laws should be coming, and they are coming, to make automated system just. I think that it's important that lawyers don't just rule it out because they think it's too dangerous or too unvague. Because then is a great missed opportunity. So I think we need to talk to each other to be able to understand what it is that should be enforced for these systems. When should they be used? When shouldn't they be used, possibly? And certainly, we're not going to use the judgments of these systems, or we shouldn't be using the judgments of these systems as fait accompli. But it could be an assistive tool to people, in helping them make decisions. And then I had a little video, because it's Friday night, and you're very good about coming here. My video is from Monty Python. And the reason that it's relevant to this talk is because my title was what can computer science do for us, okay? And it reminded me of this particular skit.
They bled us white, the bastards. They've taken everything we had. And not just from us, from our fathers and from our fathers' fathers.
And from our fathers' fathers' fathers.
Yeah.
And from our fathers' 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 fathers.
Yeah, all right, Stan, don't labour the point. And what have they ever given us in return?
The aqueduct?
What?
The aqueduct.
Oh, yeah, they did give us that. That's true, yeah.
And the sanitation.
Oh, yeah, the sanitation, Reg. Remember what the city used to be like?
Yeah, all right, I'll grant you, the aqueduct and sanitation are two things the Romans have done.
And the roads.
Well, yeah, obviously the roads. I mean, the roads go without saying, don't they? But apart from the sanitation, the aqueduct and the roads...
Irrigation. Medicine. Education.
Yeah, all right, fair enough.
And the wine.
Yeah, that's something we'd really miss, Reg, if the Romans left.
Public baths.
And it's safe to walk in the streets at night now, Reg.
Yeah, they certainly know how to keep order. Let's face it, the only ones who could in a place like this. All right, but apart from the sanitation, the medicine, education, wine, public order, irrigation, roads, a fresh water system and public health, what have the Romans ever done for us?
Brought peace.
Oh, please. Shut up!
So, fascinating. Any reactions?
I wanted to speak to techno-optimism because it seems to me that's a force in all of this that is both wonderful, and I don't want to present myself as a techno-pessimist in all of this. But I agree that there's nothing new under the sun, and I also agree that, you know, that I can't imagine not having my computer. I love what it has brought to me in terms of roads and sanitation. Another name for techno-optimism is a kind of new age manifest destiny. And that's quite dangerous. And it's being carried forth with a sense of self-congratulation and lack of regulation and monopoly power, where the guiding construct is, you know, and again, I don't mean, this is not I think it's inevitable, this is how we have to express it, you know, how can our designers put into this system something that gains trust, as though the population to trust is something that has to be homegrown within the context of its engagement with this system. But you're doing it so that you're, you know, I think there were, you know, we had conversations in which basically it is the technology developers who are giving voice to these populations, where you are never going to have trust from those who have been cultured by a democracy or a representative governmental system where, look, damn it, I have my own voice, you know, and I will speak or not speak. And so I think there's also a way in which this production of comfort or consent or engagement within this privatized model of help us make it work better is a sort of begging to be part of a utopian project, but particularly from you know, from those voices like the people who were not served by the bus, you know, who have been through certain dystopic versions of this, and that's something that I think there's no substitute for, but a kind of, you know, a close examination of unintended consequences, a close examination of where there is a kind of blind hubris in the sense that this is going to bring health, wealth, and happiness. As if you've ever seen a little film called DNA Dreams that the Beijing Genetics Institute talks about, in terms of our, you know, the more we know about all of this, it's going to bring health, wealth, and happiness, and higher IQs, and it's part of their advertising thing. And I am, again, please do not interpret that as a Luddite instinct. I'm just very cautious about the incredibly layered ways in which this intersects with society, displaces governance, disembodies sentient beings at every level, and too much confidence that this is nothing but a good thing also has to be built into that model that is, I don't know how else to, I sometimes wonder if law itself as we know it is going to be displaced by these new standards and by this, and if there's consciousness within these companies, these corporations, the search for efficient outcomes, is there a mechanism for slowing down? Is there a mechanism for the kinds of experimentation that looks over long, long periods of time? Because there's no profit in that kind of experimentation or that kind of anthropology of overtimeness as it's currently built into these models, and that's what worries me.
Well, but Pat, you used the word profit, which until then we hadn't talked about it. And which values really are governing here is one of the central questions. And if it's efficiency and profit, that is a set of values that I can respect, but that's not human dignity, equality, public welfare. And we're not having a public conversation about that. We are bypassing the democratic process. Secondly, I totally agree also with this point about time, the sense that everything is done so quickly, we don't have time to reflect. That certainly interferes with the kind of process values that Elliot talked about, and even helping people build some sense of trust, participation. The first rule of the Federal Rules of Civil Procedure, which is a meta rule about how to interpret all the rules, says all these rules shall be interpreted to ensure the just, speedy, and efficient administration of justice. Well, guess what? Those point in opposite directions. Just, speedy. And so we have the competing goals, and we do not have a hierarchy for them. And we adjust and we moderate. But I worry about path dependence in the most literal sense of, remember Y2K and the code that was built on the code that was built on the code, and we've been learning about genomic databases that are built on old concepts that were rejected, but they're still there, about race or what have you. I worry about path dependence. So in speed, things are built on top of other things that are built on top of other things that are very hard to undo. Very, very hard to undo. And that worries me a lot, because once it's done, where's the motive, the profit, the time, the patience to undo it? And the world has changed. And the power relations have changed once the world has changed. And I also worry, but maybe there's a little silver lining here, about public and private. So the very fact that the big, big decisions are being made, many of them by private companies, is worrisome for the reason that I've already said. It's not public, it's not subject to public accountability, it's not subject to the norms of the public. On the other hand, there may be more room for experimentation than if it were the government. And particularly around issues of speech, the private sector can be regulating its own speech in a way that in the United States, the government cannot regulate speech. But I would just add one more word, which is forgiveness. So we are not a forgiving people. And there are groups, and maybe all of us, have grounds for resentment for bad things that have happened, bad things that are happening. I think that we're living in an age of resentment, and so people aren't always being generous when there are mistakes. And then we really have conflict. I think we're living in a time when the Enlightenment is trouble. The idea that reason is something that should be valued, that science, news, objectivity, democracy, these are all in trouble. Well, one of the ideas in the Enlightenment was that we could actually avoid war if we found ways to elevate those other values. I worry we're going to have war in the most brutal, terrible way, because the conflicts are going to be huge, and we won't have processes or trust in them to resolve them. So in my view, the stakes are about as big as they can get.
So I agree with you.
Yeah.
that this is important, and that Monty Python was just a joke.
It took the Romans a while.
No, I mean,
All right.
my concern is not, is that this is a challenge, not just about what we are doing, it's that we actually already are displacing government with a trusteeship system, a colonial system. And until we recognize that power is
Right.
already in place.
Right.
That's what worries me.
Right.
It's not just the is becoming,
It's already happened.
It's become.
It's already happened.
Yeah, absolutely. So, do we have any questions?
Over here.
Come on, this.
Maybe get a
this-
woman.
There was a hand right
Okay.
here.
I'm calling a woman next.
Hi,
sorry.
my name's Alan Carlson, and I just retired from working 40 years in state trial court system. So I know an enormous amount about what goes on in trial courts. I didn't litigate, I ran the courts. My concern is about data, and a couple of you have touched on this. There's a lot of data out there, but my concern is a lot of the data is irrelevant. But we keep dumping it all into the pot and cooking it.
It's true.
And there's nothing about AI that I've seen that sorts out causation versus correlation. So my concern, if you can address that, is how do we get past just because it's correlated? And this goes totally to the ideas of ranking people about being released, which is appalling to me from my time in the system. Is any progress being made? And it's fascinating if Shafi's got an idea about theories about this, but it seems to me we got to be careful about what we dump into the pot before we cook it in terms of data.
I'll give an answer to Cynthia.
I would say that computer science is working on it. Seriously?
Yeah.
In other words,
We're not getting very far very fast, but I'm not.
Let's go to the
that's,
We aren't there yet. So I think we need to be more careful about using the systems, the tools, but we don't know yet
Whether there is causation versus correlation. I mean, where you live is irrelevant to whether or not you're going to show up and recidivate. But it's in the system, and it can be in there subtly. A zip code, an address, a lot of things like that. So that's my concern: is that are we getting very far very fast on dealing with that? You're being hesitant.
I'm not an expert, but I don't think so.
We had a panel on that today. It's a very
Scary.
vexed question.
Yeah.
And a fair one. Yeah.
Where was the early?
Here's a woman.
Oh, yeah. Rachel.
Hi, everyone. Rachel Cummings. I'm a professor at Georgia Tech, and I'm also visiting at Simons for the term, which is great. So I'd like to kind of turn the conversation back towards like education. And I know you three plus a fourth in the audience co-taught this like a computer science and law course. And I'm curious, what are some kind of like broader principles learned in that experience in terms of how to like better collaborate across fields? And like also, were there some clear opportunities for like future collaboration that arose through that course?
Well, thanks for that. I think one lesson for sure that I learned was that there's hunger for this conversation, a huge hunger among the computer science students, and a hunger from the law students and others as well. A second lesson that I learned is that actually working together on something is a way to get deeper. And so Cynthia and I are going to try another iteration. Shafi's going to try another iteration. I'm sure that Pat will be trying another iteration. I think we're all going to be trying to find ways to actually have people with different training work together on something rather than, parallel play, as you might describe what we did the first time around. I think we heard about some other examples at the conference that was held the last 3 days, amazing conference. People trying to have philosophers and ethicists in computer science classes. But again, not just coming in to do guest lecture, being part of the problem sets. And I think that this is all to the good. It's very striking to me that people my age, we are playing catch-up, and the students are digital natives. And even if they're law students, they are much more proficient than I am in being able to move across systems and to know what the issues are. And so my hope is that we're going to have much more student participatory led classes where people like me are going to be learning, if anything, more than the students.
So just to expand on what Martha said, it was a conversation we had this morning that what we did this first time was more like the computer science would present their things, and then the lawyers would comment on what those words meant in law, and then vice versa. But so that felt a little bit disengaged, you know. So it was an interesting experiment, but I'm not sure how deep we managed to get. And the idea that Martha told me that she and Cynthia are going to try next time is that there will be actually less topics, and just for each topic to try to really examine it from a legal point of view and a computer science point of view, and go deep and not just be surface level. And I think that's a question of time. So next time we will really take blockchains and smart contracts and compare them to contracts, say.
And we hope it'll work. We're actually, in the class we're going to offer in the fall, have one day with the students from all the backgrounds together, but then separate days, so that the law students will be meeting separately, computer science students meeting separately to get deeper in their own fields.
And I think part of it is the structure of academia. To have these conversations requires a willingness in institutions to have not just, and it's cheaper to have students coming in and having these conversations, but actually to support faculty from different disciplines to come into a classroom and have that kind of deep conversation. And you know, I co-taught a class with a geneticist at Columbia, and we argued for a whole semester about the meaning of the word natural. I mean, it just began there. But in being able to not just sort of each of us go to our, you know, dictionary of biological subsets and the legal dictionary, but actually to, over the course of a semester, excavate what each of us meant, and to do it in a way that I think that group dynamic changes when you're doing that. You're sort of fishbowling a kind of mutual exchange across authority and disciplinary lines that is very different from what I have encountered in other settings, trying to engage with geneticists at conferences where I come in as a lawyer and it's like, trust me, I'm a scientist, you don't know what you're talking about, and it never goes anywhere. I mean, there's a real, I think, disciplinary prejudice around between hard sciences and social sciences that makes these conversations very difficult. So being conscious of the academic siloing that prevents some of this from happening in richer ways.
That sounds like computer scientists aren't so bad after.
That was observed for those people who work in both. Today, people consistently said that computer scientists actually, or this conference seemed much more congenial.
All right, we've run way over time, so on that positive and hopeful note, we'll end there. And please join me in thanking our panelists for a fabulous discussion.